Hi, my name's Tom McNulty. I am an attorney with Lando and Anastasi with a focus on intellectual property litigation. And I'm here today to talk to you about developments in copyright law, both in 2022 and what we might expect in 2023. In October, the Supreme Court heard oral argument in the Andy Warhol Foundation versus Goldsmith case. This case involves a photographer named Goldsmith who took a photograph of the musical artist Prince. Mr. Warhol obtained a license to the photograph to create a lithograph for the cover of a Vanity Fair magazine. Unknown to the photographer, Mr. Warhol took that photograph and made a series of additional lithographs, which he sold on the marketplace. The photographer sued when she discovered this, as that took place outside of the license. And the main issue in the case was whether Mr. Warhol's lithographs constituted fair use and thus not infringement. Fair use considers a number of factors, one of which is the purpose and character of the use, whether it's for example, a mere reproduction or whether it transforms the work into something new and different in a way that takes it out of the realm of infringement. In this case, the district court found that the Warhol work did constitute fair use based on arguments made by the Warhol Foundation that the photograph itself was intended to convey the sort of sensitive and insecure side of Prince and the sort of reluctance to embrace the fame that he had acquired, whereas the Warhol lithograph was intended to create more of an iconic image, more of a celebratory image, I guess you could say, such that the meaning behind the Warhol lithograph was different from the meaning behind the photograph. The Second Circuit looked at this and reversed, found that there was no transformative use. The lithograph retained the essential elements of the Goldsmith photograph, excuse me, and therefore it wasn't transformative. The Second Circuit held that whether a work is transformative cannot turn merely on the stated or perceived intent of the artist or the meaning impression that a critic, or for that matter, a judge, draws from the work. A judge should not assume the role of art critic and seek to ascertain the intent behind the meaning of the works at issue. Instead, the Second Circuit believed that courts must examine the underlying nature of the copied work and whether the actual work has been changed or transformed into something new, in the sense of a portrait no longer being a portrait, and not look at what the intended meaning is behind the creation of the work. This went up to the Supreme Court on the question of whether a work of art is transformative when it conveys a different meaning or message from its source material, or whether a court is forbidden from considering the meaning of the accused work where it recognizably derives from its source material. One of the key issues in the case that I believe was fairly brought up by Goldsmith is this notion that because it's a Warhol and it carries the Warhol sort of iconic imagery, the iconic meaning behind the Warhol portraits, cannot be determinative, because that would result in artists with the fame of somebody like Andy Warhol having a much broader scope of fair use available to themselves than an unknown whose underlying intent behind their work would be hard to ascertain. This is not the Supreme Court's only foray into copyright law in the year 2022. In February, the court issued a landmark opinion holding that a section of copyright law, Section 411B, which deals with the ability to obtain a copyright when there's been an error, an honest mistake in the copyright application, whether that honest error clause refers to both errors of fact and errors of law. In this particular case, Unicolor, the case is Unicolor versus H&M. Unicolor registered 31 individual designs under a single copyright registration. They indicated that the works had been published. The Copyright Act requires an applicant who registers multiple works under one copyright application to also first publish those works as a single bundled collection. That did not take place in this case. And apparently the reason it did not take place is not that they were mistaken in thinking that they had published them as a single bundle, but they were mistaken that that was what the law required. And it was an honest mistake. It was legitimately made. Publication can be a little bit complicated. The Supreme Court held that the Copyright Act does not distinguish between a mistake of law and a mistake of fact in a copyright registration, and that an honest mistake of either law or fact is something that would not amount to knowledge of the incorrectness of the copyright application and would not result in cancellation of the application. And this is so even if, had the application been properly filed, it would have caused the Copyright Office to refuse registration. Moving down a step lower, the Ninth Circuit decided an important case. Case is Lang-Van versus VNG, and the case involves whether courts can exercise jurisdiction over foreign websites that are available in the United States, even if the person hosting the website has no presence in the country. In this particular case, VNG is accused of hosting pirated videos of Vietnamese television shows for which Lang-Van held copyright. So Lang-Van, which is a California corporation, sued VNG in 2014 in California. In 2019, the California District Court dismissed the claims, finding that the foreign company did not have enough contacts within the state for the court to exercise jurisdiction. The Ninth Circuit reversed and remanded, explaining that because the website purposely targeted American companies and their intellectual property and purposefully availed itself of the privilege of conducting business in the United States, that jurisdiction in the courts was reasonable. So that's an important case in terms of going after overseas infringers who are making infringing works available in the United States. Another interesting case in 2022, the state of Maryland passed a law that would have forced publishers to license ebooks to libraries on terms determined by the state rather than by the negotiation between the publishers and the libraries. There was a lawsuit brought challenging the constitutionality of this, and the Maryland court determined that the bill was unconstitutional and unenforceable because it conflicts with and is preempted by the Copyright Act. They recognized that such a forced transaction between publishers and libraries would strip publishers of their exclusive rights under the Copyright Act to decide whether and when and to whom to distribute their copyrighted works. In another challenge to a statute, the U.S. Court of Appeals for the District of Columbia rejected a challenge to Section 1201 of the Digital Millennium Copyright Act. That particular section makes it unlawful to circumvent technological measures used to prevent unauthorized access to copyrighted works. And it was challenged as potentially being, as applied as being a First Amendment violation. The court rejected this challenge and found that the statute was content neutral in that it targets conduct rather than speech, and that the test for a content neutral statute is intermediate scrutiny, and that the government had a substantial interest in protecting against infringement and ensuring the broadest distribution of copyrighted materials that overrode any First Amendment concerns. Another series of cases addressed whether a website that embeds a copyrighted material, embeds, for example, a photograph, but does not itself store the photograph on its own servers, whether that embedding is a copyright violation. There's been a circuit split. The Ninth Circuit has taken what's called a server test approach to this, where the person liable for copyright infringement is the one who has the photograph on the server. And if your website merely provides a link so that when somebody clicks, they get the photograph, that's not your website displaying the photograph. It's merely the servers. Whoever owns the server is the one displaying the photograph. This argument or this analysis has been rejected in several other courts, basically saying that by embedding a photograph, you're infringing the display right, the right to display a copyrighted work, whether you actually host the photograph yourself or whether you're merely putting an indicator into where on the web it's located. There's been a circuit split, at least among the Ninth and Second Circuits on this effect. The Second Circuit says that the Ninth Circuit's approach would make the display right merely a subset of the reproduction right. I tend to think they're right on that, but I'll be interested to see how this develops moving forward. One sort of interesting aspect of copyright law that's coming up, the copyright term has been extended on a number of occasions over the past decade, basically. And it seems to come up whenever the original Mickey Mouse, which is a Steamboat Willie cartoon, is about to run out of term. The copyright term has been extended on several occasions when that was imminently about to happen. The most recent time was in 1998, and it was sort of coined the Mickey Mouse Protection Act because of that. That last extension is due to expire in 2023, towards the end of 2023. And thus far, there's been no serious efforts to add to an extension. So for the first time since his creation, Steamboat Willie may well come off of copyright and be publicly available. Of course, that doesn't make every iteration of Mickey Mouse publicly available. Many of the more modern Mickey Mouse designs arose after that and still are covered by copyright protection. And of course, even if it's available under copyright, you still have to be aware of trademark infringement issues and things like that. So I would use caution before appropriating Mickey Mouse into your works. It's just sort of an interesting thing that's coming up. One of the other areas of interest I think that's coming up in 2023 is issues related to artificial intelligence generated works. And this raises a couple of significant copyright related questions. The first of which is, are artificial intelligence generated works copyrightable? Thus far, the Copyright Office has taken the position that a pure AI generated work is not copyrightable, has to be a human involved, or there's no copyright available. And they have affirmatively refused to register digital works to that effect. This sort of traces back. There was a decision several years ago involving a camera that had been dropped and a monkey picked it up and took a selfie. And somebody tried to have a copyright issued in the monkey's name. And the Copyright Office said no to that as well. But it does raise the interesting question of who would own the copyright? Would it be under the AI's name? And if so, what could they ever do with it? Would it be under the person who put in the prompt's name? Would it be under the name of the artists or the writers who basically created the works that were fed into the AI to create the work? I think this is probably somewhat of a moot issue on pure AI generated things, but the big issue is going to be, what do you do with works that were created at least partially by artificial intelligence, but also impacted by a human? So the AI creates a written text and the human edits it to some extent. What scope? Well, first of all, does anyone get a copyright in that? And if the person doing the editing does, what is the scope of that copyright? Does it cover the paper? Does it cover solely his or her changes to that paper? This is something the copyright is seriously looking at. The Copyright Office compendium says the crucial question in this is whether the traditional element of authorship in the work was actually conceived and executed by a man or by a machine. The Copyright Office did at one point in the last year grant a registration to a graphic novel called Zarya of the Dawn. And shortly after the copyright registration issuing, it gained a lot of publicity as being the first AI-generated piece of work to receive a registration, and the Copyright Office promptly canceled the registration on that basis. The other kind of interesting question that this AI raises is whether there's copyright infringement for AI-created works. If an AI creates something that's a little too close to a pre-existing copyrighted work, can you sue for infringement? And of course, the same questions arise then. Who do you sue? Who pays? Who's liable? Is it the AI software creator? Is it the person who put in the prompts? Is it the person who trained the AI? Is it some combination thereof? There have been a number of people making noises about filing suit against the AI companies for using their copyrighted materials to train the AI. And this is of great concern to writers and artists who are worried that artificial intelligence is effectively going to squeeze them out of their business. Senators Tom Tillis and Chris Coons have asked the Copyright Office to establish a commission to study AI and these issues concerning AI and try to develop some policy surrounding it. So perhaps we will see some of that as the year develops. The last major development that I want to talk about is the Copyright Small Claims Court, formerly known as the Copyright Claims Board. This began operation in June of 2022. with the idea of creating a faster, less expensive way to assert copyright infringement without, getting into full-blown federal court litigation, so long as the dollar amounts at issue are not that high. The Copyright Claims Board, or CCB proceedings, they're designed to be easily and clearly understood and usable by anyone. Not sure thus far that that's played out in practice, but they are streamlined. There's less discovery that takes place, and it is designed to be, and so far appears to be, quicker, which I'll get into in a moment. Participation is voluntary, so if you choose to bring a claim in the CCB, the person that you're accusing of infringement has the right to opt out. If they do opt out, you can still sue them in federal court and go through with a formal copyright infringement case. There's limits on what can be brought in front of the CCB. So it's limited to claims of copyright infringement, or to asking for a declaration that specific activities do not infringe copyright. And it's also open to claims of misrepresentation and takedown notices sent under the Digital Millennium Copyright Act. Counterclaims can be brought, but they have to be related to the original claim and involve the same copyrighted work. Monetary damages are capped at $15,000 per infringement and $30,000 in total. And you can get either statutory damages or actual damages that you can prove, and potentially infringers' profits if you can prove those. But again, those are still subject to the $15,000 and $30,000 caps. So that's different than federal court, where actual damages are completely uncapped, and statutory damages can reach as high as $150,000 per work if the infringement was found to be knowing or willful. If you bring a case in the CCB and it goes to resolution, you can't then challenge it or refile it in the federal courts. If you're unhappy with the result, you can seek reconsideration from the board. You can ask the Register of Copyrights to decide whether the board abused its discretion in denying reconsideration, and in limited circumstances, you can seek review in federal court. One of the interesting differences: in federal court, you have to have a copyright registration in hand to bring suit. In front of the CCB, so long as you have an application pending, you can bring the case. And the other part is, in federal court, there's a time limit by which you have to have obtained registration before the infringement began for statutory damages to be available. And that does not exist in the CCB. Statutory damages are always available in the CCB. So that's been in effect for about 7 months now. A majority of the claims that have been filed involve pictorial, graphic, and sculpture works, and largely photographs. With the advent of image recognition software, finding copyright infringements on the internet has become sort of a booming subset of copyright law. The claimants, the people bringing the claims, tend to be individuals and small businesses rather than big players. But like I say, while it was designed to be simple and easy to understand and use, it doesn't appear, at least on early look, to be so. Of cases that have gone to completion one way or the other, and none of them have gone to a board decision on infringement as of yet. But on cases that have resolved, there's been 9 settlements and 19 opt-outs out of about 250 cases that have been filed. The large majority of cases were dismissed for main reason was for filing a non-compliant claim, a non-compliant complaint. You either didn't identify the copyrighted material sufficiently, you didn't allege a registration, you didn't specify with enough detail what the actual infringing act was, things like that. 9 were dismissed for failure to provide an address for the defendant, and 23 were dismissed for failure to timely serve the complaint once it was issued. And then there were a few that were dismissed for failure to pay the requisite fees or failure to allege registration. So a pretty significant number of cases are having trouble making it through the initial complaint phase and getting a compliant complaint from which they could then move forward on. Again, that's just looking at closed cases, and it hasn't been open for very long, so there's probably a little bit of bias in those numbers, but it does indicate that that there may well be a problem. in terms of understanding. I would note that of the cases that were dismissed for non-compliant claims, the vast majority of them were filed without a lawyer. So perhaps having a lawyer involved would ease some of those problems. And finally, of the cases that remain in effect, I looked at some of the ones that were filed when this first opened in June, and the time frame to get to the final briefing, at which point the PTO can make its the Copyright Office can make its determination. It appears to be around 9 months. So at least on a time basis, that certainly is quicker than the federal courts would have been. So that's my review on copyright law. Thank you for watching and enjoy your day.